Distinguished guests, officials from MMC ASAFO, fellow colleagues from Victoria Commercial Bank, good morning. On behalf of Victoria Commercial Bank, I welcome you to probably the last webinar for this year. My name is Javed Khanna. So thank you for joining us today for this important webinar on sectional properties and conversion of long-term leases. I will just quickly take you through housekeeping guidelines. Members from MMC ASAFA will take us through the presentation on the topic of the day. And after that, we shall have a short Q&A session. So during the presentation, obviously your cameras and mics will be on mute. But we encourage you to type in any questions that you have in relation to the topic in the chat box so that the speakers can address them at the end of their presentation. We aim to close the webinar in about an hour, so let's keep it short but informative as well. And now may I welcome Rachel Kamau from our legal team to officially welcome the speakers of the day and who will then take over the presentation. Thank you. Rachel, over to you.
Thank you, Javed, and good morning, ladies and gentlemen. Imagine owning an apartment, a warehouse, or a house unit in a developed property and have the physical title in your name. Also imagine being able to get a facility from your bank directly without requiring the consent of the developer or a manager. Yes, this is now a reality, and with our talented, educated, and armed with vast experience in law, especially in areas of real estate, project development, banking, and finance, our guest speakers are here to walk with us through how this is possible and what challenges are there when registering such titles. As you've been told, my name is Rachel Wanjiko. I'm an advocate who is privileged to work at Victoria Commercial Bank in its legal department. To start us off today will be Esther Omulele, who is the managing partner at MMC ASAFO, and she has practiced in law for over 2 decades. Today, she brings with her extensive experience in banking, finance, and fintech project development, just to mention but a few. And she has been very instrumental in major projects development deals like Tilisi, Tatu City, among others. Esther also has chaired in the task force of Sectional Properties Act regulations that drafted the regulations that operationalized the Sectional Properties Act. Next, we have Isaiah Kamau, who is the Deputy Managing Director, and as the head of the Mombasa division of MMC ASAFO, he is also well-versed in matters of banking and finance, real estate and corporate commercial. He has been involved in various major clients on various banking and financial transactions, and currently, he is also involved in a real estate matter at the coastal region, including structuring and setting up of a luxurious apartment complex at the North Coast. Our next presenter will be Jessica Mwenje, who is also a partner at MMC ASAFO and heads the real estate division. She brings vast knowledge in complex real estate, structuring, project finance, conveyancing, land use, succession, and estate planning. She has been involved in major property developments such as Tatu City, Tilisi Development, Maisha Development. And when it is said to save the best for last, our final speaker is Henry Omukubi. He is an associate advocate in the real estate commercial property division at MMC ASAFO. And as a rising star at MMC, he is well experienced in real estate, commercial, and property transaction. Banking and project finance as well. He has been involved in the major real estate development, such as Tilisi and Tatu City. So, with that, ladies and gentlemen, thank you for logging in. I believe that by participating in this webinar, we are in the right place at the right time. Please sit back, relax, absorb as much knowledge from the panel, and also arm yourselves with as many questions as possible, because with VCB, our customers should experience nothing but the ultimate. Esther, welcome. Over to you.
Thank you very much, Rachel. I will request my colleague Henry to put forth the presentation. So as he does that, I'd like to take this opportunity to say hello to everyone who is at this meeting, and to also thank Victoria Commercial Bank for the opportunity to be before you to talk about what is very dear to me as a lawyer and as a practitioner, as well as a managing partner of MMC Asafo. Henry, are you ready with the slides?
Yes, I'll be sharing in a few.
Okay, thank you. Thank you very much. So I'll start by telling you in a few minutes, about 3 minutes, about MMC Asafo, so that then you understand who is before you, and so that then you have the comfort of interacting with us, asking very hard questions, because we are here today to make sure that the topic of sectional properties and how they are titled is simplified, is well understood, is demystified. So all the questions that you may have, we ask that you prepare them, and we'll be happy to answer them. So MMC is a firm that has been in existence since 1995. So it's an old law firm. We have offices in Nairobi and Mombasa. We have 7 partners and several associates who sit in both Nairobi and Mombasa. We have a team that is dedicated to the real estate practice, and that is the team that is before you today, or part of the team that is before you today. So our practice areas are starting with real estate. We have done that for very many years, I think since 2000 and about 2004 to date. And in that respect, we therefore have interacted with many kinds of developers with structured projects, some of which were mentioned by Rachel. We also handle private equity mergers and acquisitions. We do capital markets work, and why capital markets is important is because through capital markets, you can actually raise funding for projects, even those that are real estate related, maybe through REITs or products such as those. Then we have a strong banking and finance department, which is the department that works with the Victoria Commercial Bank, where we represent the bank in the preparation of securities and any other advisory that is of financial services related. Then we do energy transactions as well. We advise in the telecoms sector. We deal with dispute resolution and also litigation. And by dispute resolution, that includes arbitrations as well. Then we also handle intellectual property. And here we're talking about your brand protection, whether it's trademarks, whether it is your patents, or even industrial protection of intellectual property. Then there's mining, oil and gas, project finance, so that we are full service law firm. Now, MMC founded in 95, and then in 2019, we teamed up with an international law firm known as Asafo & Co. And that is the point at which we changed our name from MMC Africa Law to MMC Asafo. Asafo & Co. is a Pan-African law firm, international law firm, focusing really on Africa. And by teaming up with Asafo & Co., that has given us a spread across the African continent, because we now have offices in Morocco, in Cote d'Ivoire, and in South Africa as well. Out of Africa, we have offices in France, in the US, and in the UK. So if you have work across those jurisdictions, I think we would be happy to speak about that. Just move on to the next slide, please. Yeah, so that's Asafo. The total Asafo spread, we have about 180 professionals or lawyers. And out of that, we have 50 partners, and then we have 8 offices across the regions that I mentioned just now. Now, our key sectors where we have represented clients in the past and we continue to do so are education. So we've helped set up a few schools in Kenya. There's healthcare where we've assisted in transactions relating to injection of investment, maybe by private equity firms or even handling other healthcare related matters. Then innovation, technology, and telecommunications, where we act for we act for the largest telecom company in Kenya. Then there's energy and power, where we act for bodies such as KenGen and other private entities as well. Then there's banking and finance, or banking and insurance, where we represent a lot of the banks in Kenya. On infrastructure, transport, and logistics, we've handled a number of PPP transactions where we represent the PPP directorate in the structuring of some of the PPP transactions that are currently being formulated, including the tolling of some of the roads in Kenya. Then there's agribusiness transactions as well, oil and gas, and mining. A lot of the mining work is out of is not in Kenya. It's in DRC, where we have a lawyer stationed to do that sort of work. Next slide, please. Yeah, and then those are our practice areas. I already mentioned them, so you can see real estate is right there. It's one of our largest practices. And as we speak to you today, one of the things that we bring to the table is the fact that we were part of the team that formulated the sectional properties regulations. So we understand the thinking behind the writing of the law and the regulations as well, and what is happening in practice. So we'll be happy to answer all your questions as they come through. I think with that, that's all I can say about MMC. There's probably will be another day where we can speak about MMC. I'll allow my colleagues to now take us through the substantive presentation. And at this point, I think I'm handing over to Jessica.
Yes, Esther, thank you very much for that introduction. Thank you, Rachel, as well, for the very nice words of introduction to the MMC team that will be taking us through the presentation today. So I want to go straight into the presentation, and I'm going to present now. So this, the topic we're covering today, which is basically the Sectional Properties Act. And we are going to take you through the Act and specifically the relevant topics or the pain areas that are based on our practice and our interaction with the Act. The areas we've noted raise a lot of questions, as well as the areas that need an immediate attention. So we are going to look at the introduction to the Act. We are going to see how are you supposed to prepare and register the sectional plans. We are going to look at the corporation, and the corporation in this case is the entity that is being formed by statute to manage the common area. So we are going to look at it and what are the powers that has been bestowed on the corporation by statute. We are also going to highlight some of the features of the Act. We are going to look at conversion. Now, conversion is one of the areas, or it's one of the issues that is very relevant now. We note that there is a deadline that had been put in the Act that asked people to convert their long-term leases into sectional titles. The deadline is fast approaching, so we are going to look at that, what it means to convert, what are the steps that are to be undertaken in the conversion, and what would be the penalties in the event that the conversion is not done. Then we look at winding up of current management companies. This law is coming to replace an existing structure. So we already have management companies that are in operation. So what happens to those management companies? And as I've said, we'll also look at the offenses and penalties that are there under the Act. So the presentation is going to be handled by me and my colleague Henry. I'll take the first part of the presentation and my colleague will deal with the second part of the presentation. So what is the Sectional Properties Act? So this is an act of parliament that came into place on commenced its operation on 28th of December 2020, that is about 2 years ago, and it repealed the Sectional Properties Act 1987. Now the interesting thing is that the previous act had been in operation for about 30 years and it did not generate as much traction or as much discussion as we are having now with this new Sectional Properties Act. And that is one of the reasons why it was necessary to repeal the previous act. The act had not been accepted generally by the market. Many of the developers had found ways of working around the act and not incorporating the act within the developments because of the nature of that act and the provisions of that act that made it very hard to implement. So this new Sectional Properties Act came about to simplify the process of giving the properties the sectional status, as well as bringing into the Sectional Properties Act several land registration regimes under the ambit of the new act. The previous act only allowed what we call the Registered Land Act, properties under the Registered Land Act regime to be operationalized under the previous act. This meant, therefore, that if you had land and it was in another regime, you would have to first convert it into the Registered Land Act regime, then operationalize the act. This new act brings every property under whichever regime into the act, so it makes it easier. Number two, this new act, the processes are simpler, the procedures are well laid out in the regulations. As you've heard before, our managing partner was the chair of the task force that came up with the regulations. So the regulations have simplified the procedural aspects of the act. Therefore, it makes it easy to implement the provisions of the act. Now, the main purpose of this act is to provide for the division of units to be owned by individual proprietors and for the common properties to be owned by proprietors as tenants in common. So we have a building, and this building is being divided into units, and you're going to give the title to these units to individual proprietors. Then it means that property falls under the provisions of the Sectional Properties Act. Now, if there are common areas in that building and these common areas are held in common with other people, then it means that this building will fall under the provisions of the Sectional Properties Act. As Rachel had indicated, we are now having a new dawn where you, as an investor in a property that has sectional status, as an individual proprietor, you get an absolute title in your name, and this title is a standalone title. It's not tied up to the mother title. What we are having right now in most developments is you will get a long-term lease that is tied up with the mother title, so that every time you want to deal with your long-term lease, you'll always have to refer back to the mother title, either through getting consent to the developer, from the developer and the management company, so that you can deal with your title. The sectional properties moves away from that, and you get your own individual title, totally separated from the mother title, and that title gives you not only ownership of your individual unit, but also gives you your share in the common property, so that your title would read, you own apartment or office number 1, together with maybe a 10th share of the common properties. So what was the rationale? As I've already said before, the Sectional Properties Act was trying to come and simplify the registration process of common ownership of property. So it is making it easier it's simplifying that process. Number two, as I've said, it gives you an absolute title. So you have your rights that are indefeasible over that title that you're granted at the end of the process. And you also get the reversion with respect to your title. So your title no longer reverts back to either the developer or the management company, then they renew, and then you know by extension, they then renew your title at the expiry of the lease. You own that reversionary interest as an individual, and you deal with your property as an individual. The third rationale, which is an important one, is it is actively seeking to protect purchasers from rogue developers. I think the media is awash with stories of developers who after the development, they refused to give title to the purchasers, or developers who did not even finish developments, or developers who took loans and secured it with their mother title, and they did not fulfill the obligations, and banks coming in to call on to the loans and therefore sell the properties, and that makes purchasers lose their investment. So one of the main purposes of this act was to protect purchasers, and there are safeguards that are inbuilt in the act that we are going to demonstrate later on that help to protect end user purchasers. Then another rationale was to motivate financiers. We've had issues where financiers want to extend credit facilities to purchasers, but because of the issue of getting consent from management companies, from lessors, and maybe there is internal wrangles in the development, you are unable to get consent, so you are unable to use your unit to even get any credit facilities. So now, because you're getting an absolute title with your property, you're able to go directly to the bank without needing the consent of the management company or the corporation, as it's referred to in the act, or the developer. So it's easier to get financing. Apart from that, because the outgoings on the property are on your title as an individual, things like rent rates, you pay for them as an individual. So you don't get an issue where if the entire development has not paid rates, then the bank cannot extend credit facilities to you until that is sorted out. You're in charge of your own rates and rent, and therefore you're getting clearances by yourself, and you're able to then get those credit facilities. Now, the application of the act, as I had said, you no longer just need to have a freehold title to enjoy the benefits of the Sectional Properties Act. The act applies to both freehold and leasehold titles, and here leasehold titles are titles that confer that are not less than 21 years, because these are the titles that confer ownership interest to the end purchasers. So whether you have a freehold title or you have a leasehold of more than 21 years, then you fall under the ambit of the act. And this spreads across residential houses, office units, commercial retail shops, or all those types of units, provided there is a division of building into units, you would fall under the ambit of the act. The other thing I would want to point out at this stage is that following the enactment of the Constitution in 2010, there was the consolidation of the different land laws to ensure that we are having substantive substantive laws that cover all regimes of land. So right now in Kenya, we have two main land laws, and that is the Land Registration Act that deals with registration of land in Kenya, and the Land Act that deals with the substantive provisions of or relating to land in Kenya. So what this act does is that it brings registration of titles that are owned in common under the ambit of the Land Registration Act, which is the main act that deals with all registration requirements. So all titles issued under the Sectional Properties Act are deemed to be issued under the new act that deals with registration, and they follow all, and the regulations under the SPA follow the provisions that are there in the Land Registration Act. So there is a question that has come up a lot of times, and the question is the act mandatory or is it optional? So as a developer, you're sitting there, you have some 5 acres in Westlands, you want to put up apartments, and the question is, must you comply with the provisions of the act, or you can opt out of the provisions of the act? Now, the wording within the act, the provisions within the act are couched in mandatory nature, so that the act provides that if you're putting up a block of offices, for example, and you want to divide this that block into units and issue titles to end purchasers, then you would be governed by the provisions of the Sectional Properties Act. It is, however, important for me to point out that there are some very specific provisions under the regulations that provide for an exemption, and these are very specific and they are express in nature, so that if you do not fall under those specific exemptions provided under the regulations, then our advice would be that you should structure your development to fall under the provisions of the Sectional Properties Act. And we've put there on the slide what are the provisions that give us the right to give that opinion. The first one is that when you read the provisions of Section 13 and Section 43, then they make it mandatory that if you're selling, then you have to procure a sectional plan, which must be properly geo-referenced. You must be able to give this to the purchasers of the units at the point of purchase with the purchase agreement, and let them know that that this is the sectional plan for this development. So because the provisions tell you what to give the purchasers, then if you're not giving these documents to the purchasers, then you're in default of the act. And therefore this means that the applicability of the act when you're dividing units in a building for onward sale to end purchasers, then it is mandatory for you to apply the provisions of the act, apart from the exemptions, which my colleague will talk about. Now, the other thing I would like to point out, apart from the exemption, when you look at the provisions of the act in terms of the mandatory application of the act, there is one interesting provision, and that is the provision to opt out of the sectional status of a building. So in this case, if the building has already acquired a sectional status and the units have been sold out and you have purchasers coming in, the corporation, by unanimous resolution, that is 100% of the purchasers in the building must accept to opt out of the sectional status. So because of this provision, it means that the act gives an opening for opting out of the sectional status. So in as much as the act makes it mandatory for developers to apply the provisions of the act, there is an option by the purchasers themselves unanimously agreeing to opt out of the sectional status. And once you opt out of the sectional status, then the registrar is allowed to cancel the sectional plan. So that is the only opening we saw in the law that allows you to opt out, and that would be by the end purchasers themselves by unanimous resolution. So I've already talked about payment of outgoings, and what I've said is that once a building acquires the sectional status and each of the purchasers get a sectional title, then the outgoings are apportioned on each title. And here the outgoings we are talking about rates and rent. These are apportioned to each unit. So you get your own demand note as flat number 1, or as office number 1, or as shop number 1. You get your own demand note for rates, you get your own demand note for rent, you pay directly to the rating authority your own rent and your own rates. So there is no, the Act has removed that joint status of outgoings because it brought a lot of issues. You find because the outgoings would be obtained out of the service charge payable, when you have purchasers who are not paying their service charge and the management falls behind in the payment of rates and rent, then the entire development is jeopardized. In this case now, every purchaser will carry their own cross, so as to speak, with respect to outgoings. Apart from that, and I've explained it before, reversionary interest as well is corporately exercised by each owner. So we no longer have that creature called reversionary interest. And you've seen in many developments, they say the reversionary interest would be transferred when the last lease is registered. So it is a development of 100 units, 99 are sold out and registered, and then there is this one list that is not registered, and the developer therefore does not transfer reversionary interest to the management company for years on end. And this means therefore that the management company does not have the ownership of the reversion and of the common areas in the development, and the developer is left to manage that. And in some developments, we've seen developers being taken to court just to transfer the reversionary interest as well as the common areas to the management company. So now you get your own share in the common areas, and you're able to exercise, that reversion and renewal at the end of the term. So we now want to go specifically to what happens to units in a building that has acquired the sectional status, and how do you register a sectional plan, what is required, and all the provisions relating to units and to the sectional plan. So as I had pointed out earlier, if you're a developer and you want to sell, you're putting up a development and you want to sell to purchasers, what the law has very specific requirements on what you need to give a purchaser. Previously, you will give them a reservation form, they sign a booking form, then they sign a letter of offer, they sign an agreement, and they wait for completion. There were no strict requirements as to what you must do as a developer. But now, as a developer, you need to give them a purchase agreement, that is your sale agreement. Then you need to give them bylaws or the proposed bylaws. And these bylaws are what are the constitution of the corporation. The bylaws contain the rules that will govern the corporation. So you need to give them that at the point of sale. The other thing you need to give them is a management agreement, if there is any. For example, if you're going to put in a professional management company to run the development, you need to give them that management agreement or a proposed management agreement if you have it. Then a recreational agreement if there would be someone coming in to run the recreational areas. Then you need to give them the lease or the title of the parcel on which the unit is located. Yeah, so it is mandatory that you give them a copy of that mother title. Then if you've taken a security, if you've taken a facility and you've offered the land as security, you will need to give them that charge. And you will see later on that it's simply not enough to give them the charge. The law goes further and requires you to give them information on the charge. For example, the law requires you to tell them what is the loan amount, what is the period that you're going to pay this loan, where are you now in terms of payment of the loan, what is the amortization period. So you have to give a lot more information to purchasers. As I had said before, the main rationale of this law was to protect purchasers from rogue developers. So you're finding that the law is very strict to developers with respect to what you're supposed to give the purchasers. And the last thing is a sectional plan or a proposed sectional plan. Now, this is a very interesting requirement, and there is active discussions right now in within the legal profession as well as the survey profession on what exactly does this requirement mean, because the surveyors are saying that you really cannot have a proposed sectional plan because a sectional plan can only be made when the building, the structure, the superstructure is up. They have to measure the physical corners of the building to come up with a georeference sectional plan. So there is no proposed sectional plan unless it is at that point when the superstructure is up and maybe building some variations once the building is finalized, although there would be no changes. So to the surveyors, there is really no proposed sectional plan because the sectional plan is made at the point when the superstructure is up. Now, the question that this brings, therefore, is does the Act do away with the off-plan selling of units? Because if you're required to give a sectional plan to a purchaser, what does that mean if you cannot give that sectional plan before the superstructure is up? Does it mean, therefore, that developers will no longer be able to sell off-plan units? Of course, the jury is still out on that. The position of the law is that it is mandatory to give purchasers at the point of sale the sectional plan or the proposed sectional plan. So we will have, I'm sure we will, as the Act is being implemented, we will have situations where developers might have to, enter into letters of offer, hold on to the agreement stage until, the building is up, at least the superstructure is up, so that they are able to comply with these provisions of the law. Now, I've talked about this. When you've charged, these are what you need to disclose to the purchasers. All this must be disclosed to the purchasers so that the purchasers are not shocked thereafter when they've come in and a financier is calling up the loan because of default. Now, I know most of us listening in today have invested in units that you're not living in, you're renting it out. So it is within a commonly owned development and you're renting it out. Now, there are specific provisions for when you're renting out your unit. And one of that is that you must give notice to the corporation of your intention to rent. And you must give your address, you must tell who you're going to rent to, and also you must give an undertaking to the corporation for that you will be liable for any damages. Yeah. And then if the tenant exits, you then also must give notice to the corporation. Now, why is this important? It is important to ensure that the bylaws and the laws that have been made with respect to the development are also complied with by the tenants. We've had situations, especially in residential areas, where a tenant comes in, they are not aware of the covenants in the lease. So maybe the covenants in the lease provide for no pets. The tenant is not aware, and they bring in their dog in, and the management company tries to tell the tenant, we cannot allow you here with the dog, and it becomes a big issue. So this just allows, gives a framework to ensure that the tenant is aware of the laws or the rules that govern that development, and that ultimately the owner is also aware that any damage, liability stops with them in terms of ownership of that unit. Now we are going to look at the preparation of the sectional plans and what you're supposed to do, either as a developer, and if you're a purchaser, what are you going to look out for? So what is a sectional plan? It is a plan that must be a georeference, and it shows the demarcations, the boundaries of the units. Now, what has been happening up to this point is that you would be allowed to register your lease with architectural plans. So the plans that have been drawn by the architect, you would use that to register the lease. Now, those plans do not tell anyone where that unit is. If you just have that booklet, the lease, together with that plan, you cannot tell that this house is in Westlands, or this house is in Ruaka, or this house is in Parklands. You can't tell that unless you read that document. Number two, you cannot independently verify that whatever has been put in that architectural plan is actually what is physically on the property. So you can't tell that this is, just by looking at the plan, that this is actually the third floor unit 3 on the third floor. You can't tell that. What georeferencing helps with is that the coordinates are specifically indicated by the surveyor, and any surveyor can be able to put in those coordinates, read them, and pinpoint exactly where that unit is, so that you're having a title document that can be referenced by the surveyor at any point in the world, and they can tell you exactly that this unit is in Westlands, it's in this property, and it is on this floor of this building. So that is basically what georeferencing does. It gives you a sort of a deed plan for those of us who are familiar with the title that comes with a deed plan. The georeferencing is sort of giving you a deed plan for your specific unit. So that is what must be there. So you start from the plans that have been approved by the county, you do the survey processes, and then at the end, you register that plan. So it is a more rigorous process. You no longer just get your floor plans, attach them to a list, and register it. So what must be provided in the sectional plan? So there must be a heading about the plan, and basically it gives you the development, it gives you the name of the development, who the owner is, and all that. Then it gives you the reference for the title. So it shows specifically, this is the title that we are talking about. It gives you the units. So the units will be indicated on the plan, and it will have unique identifiers. So when I talk about unique identifiers, it's really just the numbering for each unit, so that it is clear and it is distinctive. It distinguishes one unit from the other. It must show the floor area, and as I've told you, when they're putting up when they're drawing the sectional plan, the superstructure must be up, because they actually measure the corners of each unit and come up with the floor area. Then they show the unit factor. Now, the unit factor is a formula that shows that, I think it is to the power of 10,000, that shows, your ownership, and it also influences your share in the common areas. So it will show that on the sectional plan. It will have an address. It will clearly indicate the user. So there is no way, after the sectional plan has come up, the developer can now say, no, this is no longer a clubhouse, it is a residential house. So it clearly indicates this is the user for the unit. Then it has a certificate from the county government. So number one, that structure has been approved. And once that is done, the county endorses that sectional plan. So you no longer have a situation where a developer gets approval for plans, then they go change those plans, put up something different, and there is no mechanism to go back and confirm. So in this case, there is the approval that was initially given. Then when the sectional plan has been done, it goes back to the county. The county confirms that it aligns to what they had approved. Then they endorse and they give a certificate for that. Then, as I've said, the user. Then it is signed by the proprietor. It will be signed by a licensed surveyor, and it will be signed by the director of survey. So you see there are those checks and balances that have been introduced by the Act. So this is a sample one. If you see, I'm sure maybe you might not see it very well, but it shows the unit, your unit type, the area, then it has the unit factor and the user. If you go down, you will see there the details, yeah, on it's signed by a licensed surveyor, and there is a certification. There is the registration details. I wanted to show you here. You can see there is that certificate by the county again. It goes back to the county, and the county gives that certificate. There is an affidavit by the owner to confirm that this is correct. There is an affidavit by the surveyor, again to confirm the same. And then now it goes to the registry for purposes of registration. So you see, these are all inbuilt in the sectional plan. So once you've finished the drawing of the sectional plan, it goes for registration. As I've said, there is a specific form that is used to register it, and it must be accompanied by the mother title, the title for that development. Once you register that sectional plan, the effect of registration is number one, there is a surrender of the mother title. So the register for the mother title is closed, and they open now new registers for the sectional titles. So if, for example, the development has 50 units, you will take your mother title, that was one, then it is surrendered. And when you register the sectional plan, you get out of it the 50 titles for that development. Number two, there is the registration, or the registration of the corporation. So the corporation, at the point of registration of the sectional plan, the corporation is also, I am hesitant to use the word incorporated, but allow me to use that. The corporation is also incorporated at that point. Remember, the corporation, in as much as it acts like a company, it is not registered under the Companies Act. It will be registered at the point of registration of the sectional plan. And then, as I've said, you get now the units for each of the individual units. You get the titles for each of the individual units. So this is the summary of the process flow for registration of the sectional plans. I'm now going to allow my colleague Henry to take it from here. Henry, please proceed.
Okay, thank you, Jessica, for that powerful presentation. I will now take you through the remaining part of the presentation, with the first step being the population bit. Now, unlike the previous regime where we used to have a management company, we presently have a corporation that is anchored in law. So when you present your section of plan for registration, you're supposed to also make an application for registration of the corporation and provide a list of the. Let me just share just a minute. Okay, so when you're making an application for registration of the sectional plan, you're supposed to also apply for registration of the corporation. As Jessica has mentioned, the provisions of the Companies Act will not apply to the corporation. It will be governed by the Sectional Properties Act. And unlike the 1987 Act, where you were not given a certificate of registration, this corporation comes with a certificate of registration. Then it is updated as and when the ownership of the units change. So I'll go to, so establishment is provided for under Section 17 of the Act. The corporation constitutes of all the persons who are the owners. It's a corporate entity with perpetual succession and has capacity to sue and be sued in its own name. So the duties of the corporation. So the corporation basically replaces the management company, only that in this case, it will not be acquiring reversionary interest, because once the unit titles are issued, your share in the common areas is noted in the title. So the corporation will basically be for purposes of managing the common areas, which includes ensuring and keeping all buildings in the common areas insured, controlling and management of the common property. Then it will also be in charge of maintaining a fund for the smooth running of management of the common areas. And the Act allows the bylaws to prescribe other powers for the corporation, but the ones that are provided for under statutes are the three. Then we go to composition of the board of the corporation. So a corporation, being a corporate entity, cannot carry on its functions by itself, so it needs a board. The board is to be constituted within 90 days after 50% of the units are sold. So if you already started selling the units, once you sell 50% of them, then within 90 days from that date, you set up the board for management of the common areas. Or if you're not able to achieve the 50% threshold, then once you sell one unit, you wait for 180 days. Sorry? Okay, sorry for that. So if you are not able to achieve the 50% threshold, then once you sell the first unit, you wait for 180 days, then you set up the board to run the corporation. Then the corporation is supposed to have annual general meetings, which have to be conducted after every 15 years of the previous AGM. Then voting at the corporation. So voting will basically be based on the unit factor, and the unit factor, looking at the plan that Jessica had shared earlier, it depends on the size of the unit. So unlike previously where each share used to have, each unit used to carry one share, voting in the corporation will be based on the unit factor. So based on the size of the unit, and where there is a charge, the corporation has to notify the chargee, because if there is a charge, then the chargee will be required to vote instead of the registered owner. Then if a unanimous resolution is required, only the chargee can vote. But in other cases, if the chargee is not able to vote, then the registered owner can vote in the place of the chargee, only if unanimous resolution is not required. Then at the meetings, so the registered owner or the chargee can vote either by themselves, or they can appoint a proxy to vote. If it's a minor, then in law you have to appoint a guardian to vote. If there is no guardian, then the public trustee appointed under the Trustees Act will vote on behalf of the minor. And in the event an owner is not able to vote for any reason, maybe they are insane or something, then a person authorized in law is allowed to vote on their behalf. Dispute resolution. Now, for disputes, the corporation is empowered to set up an internal dispute resolution committee on a need basis. So it's not a permanent committee. It's usually set up on as and when it's required. And then the person contravenes any of the bylaws, they are taken to the committee for disciplinary proceedings. If you are not satisfied with the decisions of the committee, you can always appeal to the Environment and Land Court, which has the same jurisdiction as the High Court, but only deals with the environment and land matters. Then there are some decisions that require unanimous resolution of the corporation. And one of them, Jessica had mentioned, if you want to opt out of the sectional property status, that one, all the registered owners need to vote and approve before it can be implemented. Then also, if you want to lease to an owner of a unit any part of the common areas, then unanimous resolution has to be made. If the corporation needs to execute on behalf of owners an easement, so an easement, what basically means is that it gives third parties rights of access to the common area. So if that needs to happen, then all the unit owners have to consent. Then disposition of common property. For instance, if you want to lease out part of the common properties to third parties for whatever purposes, then a unanimous resolution of the corporation, the board, the corporation is required. Then a resolution not to insure and keep buildings insured. So if you opt not to insure for any reason, then all the unit owners have to approve that. Then, of course, termination of the sectional property status of a building. Now we move to other notable features of the Act. And what so far we've been just dealing with the specific provisions categorized under units, introduction, then corporation. But now we're going to point out features of the Act that we thought are of importance for the audience to know. So the first one is gains for secured lenders. So as I've mentioned, if you have a property that is charged, then the chargee is allowed to vote during the corporation's meeting, and they can do so either personally or appoint a proxy. Again, the unit has independent titles. Each unit has an independent title. So if you want to charge, you can always charge the unit without going to the developer, because the unit belongs to you and your share in the common area is already noted. So there's no issue of consent of the management company again. Then the owners, since they will be having their own units, they'll be paying rents and rent directly. So it will be easier for you as a financier to verify if all the payments have been made. Then the consent of the corporation, of course, we've already mentioned, it will no longer be required since the unit owners will have independent titles. Then we go to regulations to give effect to the provisions of the Act. So the Act requires the Cabinet Secretary, that is in charge of the Ministry of Lands, to make regulations. The regulations came into effect on 26th of November. I want to repeat, as my previous presenters have mentioned, our managing partner was the chair of the task force that came up with these regulations. So we are well versed with the regulations, and they contain procedural aspects of the Act, and this includes standard forms applicable in registration of sectional properties, conversion, and winding up of management companies. Now we move to conversion. Now, the Act requires all long-term leases that have been registered before commencement of the Act to be reviewed or revised so as to comply with the provisions of the Act. And to do this, the Act provided for a timeline of 2 years from its commencement date, which was 28th December 2020. So the 2 years are set to lapse on 28th December 2022. It's not clear as to whether an extension will be granted, but we hope that one will be, that the present Cabinet Secretary will grant an extension. So if you had already paid duty, you will not be required to pay during the revision process. So it's just it will just be about preparation of the sectional plan and surrendering the title for conversion. Then if you're not able to register before 28th December 2022, the Act allows the registrar to register a restriction against the title, and the essence of the restriction will be to prevent any dealings on that unit. So you'll not be able to charge or transfer the unit if you've not complied with the conversion process. And if the extension is not granted on 28th December 2022, then this provision will come into effect and a restriction may be registered against properties that have not complied. Now, the Act provides for long-term leases that are required to be converted. And these are where all the units have been transferred, and the reversionary interest has also been transferred to the management company. So you have the developer who has sold all the units and transferred the reversionary interest to the management company. In that case, the management company and the owners of the respective units will be required to apply for conversion. If all the units have been transferred and the reversionary interest is also intended to be transferred but has not been transferred, then in that case, you'll also be required to apply for conversion. Or if you've not sold all the units, but you've sold part of them, and the reversionary interest is required to be transferred to the management company, then in that case, you'll also be required to apply for conversion. So there are 3 instances. 1, you've sold all the units and transferred reversionary interest. 2, you've sold all the units and transferred the units to the end buyers, but you've not transferred reversionary interest. And then 3, part of the units have been sold and reversionary interest has not been transferred, but is intended to be transferred to the management company. And the Act also provides for units that are exempt, long-term leases that are exempt from conversion. And one of them is if you had entered into an agreement where it was expressly provided that the developer will retain reversionary interest, then in that case, there is no need to convert to sectional titles. And that retention should not only to hold on behalf of the management company, but the developer is retaining reversionary interest as the legal owner. Then other category is large use mixed-use development that are being undertaken in phases. These are also eligible for exemption, provided that reversion is to be retained by the developer or is to be held by the management company. So large, it has to be a large mixed-use development and is being undertaken in phases. Then we also have projects of strategic national importance and special economic zones, which by their nature renders them impractical to relinquish reversion and interest. For instance, if you are a developer in a special economic zone, there is usually a requirement that you always be around so that to ensure that the provisions of the special economic zones and the conditions imposed under your license are complied with. So in that case, then you don't need to transfer reversionary interest, therefore being exempt from conversion to sectional titles under the regulations. And if you have a charged property, how does the conversion process work? Now, if there's a charge over the property, the owner of the property prepares the application, has it signed. Then when it comes to submission, it's not the owner that submits, it's the chargee, the person holding the charge over the property that submits it for registration. And once the sectional plan is registered, the encumbrance that was on the title is also transferred to the new title that will be issued after the conversion process. Failure to register to convert by the registered proprietor will not invalidate the existing security, so you're still covered under the Act, even if the registered owner does not make the application, because I know there may be resistance from registered owners noting that the property is not in their hands, so they may want to frustrate the process. So in that case, your security will still be valid, notwithstanding that the owner has not made an application for conversion. Then in the event that you as the chargee want to sell the property pursuant to the statutory power, then the registrar will just register the transfer and issue a new title in the name of the transferee upon registration. So non-cooperation by the registered owner will not invalidate the charge and will not affect the process of exercising the statutory power of sale. Then the conversion process, it basically starts with the preparation of the sectional plan, noting the ingredients that had earlier been mentioned by Jessica. Then presenting the same together with the sublease, the long-term lease, or the certificate of lease based on the title that you're holding to the registrar. It should also be accompanied by a copy of the mother title, and where it's not able to get the mother title because maybe you're getting resistance from the developers to surrender the original title for conversion, then in that case, you will be required to do an indemnity to the registrar, whereafter the registrar will issue a notice in the Kenya Gazette, requiring the owner to submit the title. If 60 days lapse and the title has not been surrendered, then the registrar will proceed to undertake the conversion process by registering the sectional plan and issuing new titles for the converted units and close the parcel register, even though the original has not been presented for cancellation. Then what happens to the existing management companies? So once you move to the sectional property status, the management company that is currently in place is supposed to transfer all its assets and liabilities to the corporation within a period of 1 year from registration of the corporation. Remember, the corporation is always registered at the point of registration of the sectional plan. So 1 year from issuance of the sectional titles, the management company is supposed to transfer all its assets and liabilities to the corporation. And then presently, we have leases which contain many terms. They are usually bulky documents. So if there are some provisions that you like to still continue operating, then the bylaws of the corporation may be amended to include some of the terms and conditions that are currently in the lease. Then we go to offenses and penalties under the Act. So the Act prescribes a hefty penalty for failure to comply with the provisions of the Act relating to conversion. So it provides for a penalty of Kenya shillings 20 million for anyone who fails to comply with conversion provisions. Then there is a general penalty of 250,000 to each board member who fails to comply with the provisions of the Act. So the provisions of Act being mandatory have to be complied with. Otherwise, each and every member of the board who fails to do so will be liable to a fine of Kenya shillings 250,000. And that's the end of our presentation. We invite questions. Thank you.
Thank you very much, Henry. Rachel, with your permission, I've seen there are already some questions in the chat. Maybe we can start with those and then we take maybe any oral questions and answer. Is that fine?
Yes, that's okay.
Okay, thank you very much. So the first is by Nancy, and that is with respect to sharing of the note. I think that is fine by us. We will liaise with the team at the bank to see how the presentation can be shared. Then the second question is by Valentine, and the first one is, what happens to the title that I currently hold and has not been converted? So so the titles that, so as per our presentation, there are different categories of people who are required to start the conversion. So it's either the developer or the management company, and if these two fail, then as an owner, you are also allowed to start the conversion process. The difficulty with you starting the conversion process as a single or an individual owner is that you see the process is communal in nature. You need the mother title. Of course, as per our presentation, there are aspects where if the mother title is not presented for surrender, the registrar is allowed by law to receive an indemnity from the owners and go ahead to do away with the requirement of presentation of the mother title and just proceed with the conversion. But remember, you still have to do the sectional plan. You will have to register that sectional plan. Doing the sectional plan is an expensive process. There are discussions right now with the survey, the body with respect to the surveyors, where they're going to come up with a scale of sorts on what they'll be charging per unit in terms of the sectional plan, sorry. So it means that you as an individual, you may need to bear this cost. So ideally, the best way is to lobby with all the other owners so that you handle this as all the owners rather than as an individual. But as an individual, you can still go ahead and do that. It is allowed by law. The second question is, what happens if my title is held by third parties like banks and it's due for conversion? As stated in our presentation, you as the owner of the title, you still trigger the conversion process. You make the application, then the bank is the one that will present that title to the registry for conversion. And when the new title comes out, it will come out with the encumbrance noted on the title, and it will be given back to the bank. So the law already has looked at that scenario and has made and has provided for what should happen in that event. So you trigger the application, but then the bank presents the title, then the title will be given back to the bank with the encumbrance noted against the register. Then the next question is, what are the consequences? So my colleague has just covered that in the last slide. There is a heavy penalty in there for failure to convert. Now, there is very active steps right now by the LSK to formally extend this period. The reason for this is that, number one, the regulations came in more than a year after the commencement of the act. So we did not even know what is the procedure for conversion until after the regulations came in. So there is a whole year that was eaten up just by the making of the regulations. So that is a very good ground for extension of the period. Number two, the registry is also not ready. They are still putting plans or mechanisms in place for purposes of conversion. For those of us who've already registered sectional plans, you will note that even as at now, when you register a sectional plan, the corporation is not being incorporated automatically because the registry has not yet put all the proper mechanisms in place. So we are fairly confident that this period will be extended. We are very confident that that period will be extended, and we are hoping to get formal communication with respect to that extension very, very soon. So for the existing management companies, I think here you're asking about what happens to them after you acquire the sectional status. So as has been indicated, when you register the sectional plan, the corporation is established. Now, after the corporation is established, the law requires the existing management company to transfer any of its interests to that corporation. Then after that, the management company is required to be wound up. So it will go through the winding up process, because remember, the management companies that have been operational during this time are normal companies, limited liability companies under the Companies Act. So the process of winding up will follow the winding up process under the Companies Act. Then for a corporation holding an AGM, they therefore not only invite all owners, but also all charges for any unit that has a charge over the unit. Yes, you're correct. Remember, the chargee now, the bank has been given a right under law to sit in the meeting and to even vote. So the banks are required to be notified. Remember, if you take a charge, you're required to notify the corporation. So the corporation will notify the charges, and they can sit and vote, unless they, by proxy, they just allow the owner to proceed with the normal routine decision making of the corporation. So those are the questions under the chat. I don't know if I've missed any. Rachel, I am handing over to you to maybe take for other questions that may be coming up directly from the participants. Then we'll hand over to our deputy managing partner, Mr. Mungai, to give the closing remarks. Rachel, over to you.
Okay, thank you so much, Jessica, for that. I can see there's one more which has come in, and it states it's more or less like a continuation. Therefore, even all tax liabilities of management company have to be settled, and as corporation gets separate PIN. Jessica?
Okay, so yes, the liabilities will be transferred to the corporation, because all interest liabilities, everything will be transferred to the corporation before the winding up of the management company. Now, whether the management company will have its own PIN is still up for discussion. Remember, the law provides that the company will not be a trading, the corporation will not be a trading company. So it's not supposed to trade. Whether then they will issue it with a PIN, we are still waiting to get guidelines on that, noting that they will be, you know, they'll be paying for services, they'll be engaging service providers, and some of those services would be vatable by the service providers who are providing those services. So we are waiting for the guidelines. As I mentioned earlier on when I was answering the question on the conversion, the registry itself is not yet ready, especially with respect to the corporations. For the sectional plans that we have registered, the corporation has not been established yet because the registry has not put in place mechanisms to set up the corporation. So we are still waiting for guidelines on exactly how that corporation will work and whether it will get a separate PIN. So I think there's a last one there. So all in all, not completely there. Yes. As for any law where, you know, when there is a new law, the thinking process happens as the law is being implemented. So of course we expect some hiccups here and there, but we expect that this new law would be more successful than the previous Sectional Properties Act 1987, and the appeal has been noted. The chair is actively looking for that extension, but the LSK as a body has made a formal request for that extension. No. So the next question is, are the long-term leases registered under LRA exempted? No, they are not exempted. There are only 3 categories of developments that are exempted. Remember, as I said previously, that all titles registered under SPA would be deemed to be registered under the Land Registration Act, because the Land Registration Act is the main act that deals with registration of titles in Kenya or registration of interests relating to land in Kenya. So all of them are deemed to be registered under the LRA, and you will see that interplay in the SPA as well as the regulations under the SPA. So there is no blanket exemption under LRA, no. That is not there. Only those 3 categories that my colleague talked about, you know, large mixed-use developments that are being applied in phases. They are the projects of strategic national importance, and there is the 3rd category that is keeping my mind just now, but there is a 3rd category that there is, where it is expressly provided in the documentation that the reversionary interest belongs to the developer as a legal owner and not a trustee. They actually own the reversionary interest. They are not holding it in trust for all the owners there. So those are the only 3 categories. Thank you very much. Back to you, Rachel.
Okay, thank you so much for your presentation and also articulately answering all the questions that have come in. To the participants, please, if you have any more queries, kindly just direct them to us. I believe even MMC Asafo can respond to you even after this webinar presentation. As and when now you need, we can just liaise with them, and then they can get back to you on the queries that you may have. Now, in addition to this, I would like to invite Mr. Mungai from MMC Asafo to give us his vote of thanks. And then after that, I will proceed to hand over to Ruth Mwasia.
Thank you very much, Rachel. I think at this point, because you've taken quite a bit of time, I'll quickly wrap with the vote of thanks. And first, would like to thank the Victoria Commercial Bank team, led by Javed, and the legal team, of course, led by Ruth and Rachel. We totally appreciate this opportunity to take through your team as well as your clients through this very informative session. And I think which is very important at this point in time, where we are moving into transition, conversions, and many other processes happening at the lands registry. So we hope that this session has been not only informative, but has also provided guidelines to your clients and the legal team on the way forward in view of the current scenario. I think I also want to appreciate your clients greatly because of their patience and, of course, the commitment to create time to attend to this webinar. We believe this is the beginning of a very long-term relationship with not only Victoria Commercial Bank, but also with your clientele as we help them to navigate through very complex issues that have been raised. And of course, we want to assure them that we will ably handle the issues that will come through from this session with a lot of care, and of course with reasonable expenses to them. I know that's a big challenge to most customers. Would like to let you know that we are extremely flexible in our dealings with all your clients, and we'll be happy to work within the available budgets in order to ensure that we all have everyone go through. Now, with regard to the way forward, we want to leave it to the FCB, to the Victoria Commercial Bank's legal team, and of course, guide us on the next process in terms of interacting with anyone who may have any challenges. But we want to also provide all our emails to the team, to the legal team, so that if anyone would like to reach out to any of the presenters, to the firm, you will have our contacts as well as our email addresses. Our physical address is at Spring Valley. We'll also share that off Peponi Road. So anyone who is around can be able to pop in, ask for Jessica, Henry, Esther, or myself, and we're more than happy to take you through whatever issues that you may be having. Other than that, we are most grateful for the opportunity, and of course, we look forward to many more in the coming year. I would like to take this opportunity to then wish everyone a very safe, happy, festive season. God bless. Back to you, Rachel.
Thank you so much. Thank you so much, MMC team. And now I hand over to our legal manager, Ruth Mosia. Take the floor.
Wow. Good morning, everyone. Too excited to see all of you. Actually, particularly excited to know that you could spare time to just attend this great webinar. Just to say thank you to everyone who spared, I guess it's 1.5 hours of your time to just be part of us. Thank you. And just like all good things in life come to an end, so this webinar is also coming to an end. But I would not want us to leave before I appreciate everyone on behalf of Victoria Commercial Bank for joining us, and your contribution has made this webinar a success. I also want to thank you specifically, the team from MMC Asafo, for preparing and being a crucial contributor to this webinar. Sectional properties, as we all know, has been quite, I must say, a pain point for most of us, but we just want to thank you for your expertise, for your knowledge, and we must say that at least we leave out of this webinar equipped with your knowledge and with your care, and also with some of the insights that you've given us. And we just don't want to take it for granted, but want to say thank you. We want to thank every speaker who's spoken today, and appreciate the fact that you've spent a lot of time to just make this presentation a success. So receive our gratitude from Victoria Commercial Bank, from our staff, and as well as our clients. I also want to give our special thanks to our esteemed clients for always partnering with us, even in such events. We don't take it for granted. While the bank is committed to offer you the ultimate experience by offering you various banking platforms, it's also something that the bank strives to always bring you timely and resourceful information that it impacts your everyday life, just to make sure that even as you bank, you are comfortable in your other aspects of life. And this is one of the opportunities that we thought we could actually do that. And this we have only been able to achieve because of your commitment to us, and you've always been committed, and for that we say thank you. I cannot go without appreciating the organizing team. Thank you so much, Rachel, Javed, and Yasin, as well as the organizing team from the MMC or SAFO team. We just want to say thank you for all the work that you've put behind the scenes to ensure that today's session was a success. And our heartful thanks to our board of Victoria Commercial Bank, of course, led by our chair, Mrs. Kate Kisheth, for giving us the powers and the opportunity to hold this webinar on behalf of the bank. Thank you, everyone. And as Mongai said, I just want to take this early opportunity to wish each and every one of you happy festive season, and looking forward to always engaging with the team from MMC Asafo. Before I hand over to Javed, just to assure our clients that they have been of great support to the bank, and we can assure you that we only bring you people who have been tested and tried, and especially in this area, that's why we had to seek for the person who's been sitting in the commission, just to make sure that we receive from the best. So if you have any queries or you'd want to partner with them or the bank in any way, please feel free to always reach out to us. We are always here for you, and we'll always continue being here for you. Experience the ultimate. Thank you. Javed.
Thank you. Thank you so much, Ruth, and the team at MMC Asafo. Truly appreciate the insightful webinar. And thank you everyone for attending, and happy holidays in advance. Thank you.
Happy holidays. Bye-bye.
Thank you. Bye.
Bye.